I'm Bunny Hodis. I have the honor of being the president of your board of trustees, and I also have the honor of having a personal and professional relationship with our speaker today, Allison Kierman. And so I get the pleasure of introducing her to all of you. And folks, I'd like to say hello on Zoom, give you a few logistics as we get started. For the folks on Zoom, we have Victoria Myers is our Zoom chat operator today. And so if you have any questions, be sure and put them in the chat, and she will translate them up here to Allison. We'll probably be doing most of the questions and answers at the end of the programming, as opposed to during. But if you're having some kind of a problem, not hearing things or whatever, just put it through and know that someone in here is participating with you on there, so that we're all in this together. So anyway, I want to tell you a little bit. Allison is going to present an estate planning seminar, and I'm just going to give you a little funny thing. When we were, I'd been talking to Dale, my husband, about, before we were getting married, about doing this estate planning, and finally he said to me, after a couple of years of mentioning it every once in a while, he's like, honey, I don't have an estate. And you know, that idea of there's a big thing out there. And I looked at him and I said, but if you die and you don't have anything planned, I said, your cat is going to your sister in Chicago. And he was like, oh, okay, I'm ready. So along with everything else. Anyway, I have some good UU friends that I met through my association with UUSC, our service committee, and they live in Austin, Texas, and their daughter, they have a 3-generational family there. Their daughter, who is also an attorney, and her husband and their 2 grandchildren are all UUs in the area. And my daughter happened to be living there getting her PhD at the time, and I had the pleasure of being hosted by them and getting to go out to lunch with her daughter Liz. And I said, I really need what you do, an estate planning person here in Arizona. And she said, don't worry. She said, I'm going to get right on it, and I'm going to do some personal research, she said, before I turn any names over to you. So the only name she turned over to me was Allison Kiernan, and I went over, and I was very thrilled to be working with Allison. I'm a independent business owner myself, so I liked somebody else who was doing their own thing and had their own business going, and you could meet one-on-one with them rather than being just a little fish in a big pond firm kind of thing. And the funniest part of the story is that I was used to working with attorneys that only talked in documents in what they call legalese. You know, I'm sure you all are familiar with that. It's like, if it's a legal document, I'm going to sleep before I'm really reading the thing, honestly. So when Allison said, this is what we're gonna do, and we're gonna prepare all these papers for you, and I'm gonna send them all over to you, and you can read them over, and then, you know, and we can go over them in our next meeting. And I kind of smirked. I said, yeah, I'm not opening them. I'm not reading them. You know, I said, we can read them together when I get together with you. And so we had our second meeting, and we got together, and there were the documents. I opened them up and I went, well, I won't say exactly what I said, because this is a, you know, religious organization here. And I said, oh my gosh, I said, this is in English. Like, I can read these documents. Like, I can understand these documents. And she goes, yeah, that's a new thing. So, you know, it's pretty exciting when you can actually interface with an attorney, understand what they're saying, have them really looking out for your best interests. And so when the foundation came up and said, we're going to do the estate planning seminar, I said, well, I would really love if we could ask my estate planner to come on and share this all with you, because I know she'll do a great job. So let me just the real bio. That's okay. Anyway, she's originally from Texas. She attended Baylor University in the London School of Economics and Political Science and the Iowa College of Law. She's moved here. She's been in Arizona since 2005. and has worked at some big firms downtown, and she became a partner in one of those firms in 2015 before leaving the big law practice. In 2017, she started her own firm, Kierman Law, as a way to be more present in her family's daily lives. She specializes in trust and estate law and works with families to ensure their estates are organized. And by the way, again, an estate could be your car, your bank account, your pet, your children. Allison's also actively involved with her children as a dance mom, a Girl Scout, Boy Scout volunteers, soundstage hand. Philanthropy-wise, she serves on the board of Congregation Beth Israel and the National Council for Jewish Women of Arizona. And she also has 2 dogs, Labradoodles. And she thinks that they might be cuter than her kids, but we won't tell her kids that she said that. So I'm going to turn this over to Allison, and I hope you all enjoy the seminar. Thanks for being here.
Thank you so much. I don't think I've ever had such a nice introduction before, so thank you. Estate planning seems really boring. I definitely know that. So I promise I won't keep you too long because you might be hungry, but I also will try really hard not to bore you. A couple of years ago, somebody said, based on what I do, that I was probably a really boring dinner guest, and who would ever invite me over for dinner? And aside from being personally offended, since I'm very interesting, I also was like, you don't understand what I do. I listen to people tell me about their lives all day, every day. If they have money, if they lost money, if they like their kids, if they prefer their pets, right? Big or small, simple or complicated, everything I do is interesting because I just get to know people and things about them every day. So I'm sure you're interesting and I would love to hear your stories. So if you have questions later, I hope that you share them with me. So when people think about estate planning, often they're like, I don't have money for that. That seems super overwhelming. And it definitely can be. And it's not necessarily for everyone. A lot of people ask me, what is a good client? And I say a good client is someone who's looking to get organized. It could be simple or it could be complex. All that matters is that you have a desire to either prepare for if something happens to you and you pass, or to prepare for being incapacitated, right? So I do wills and trusts, financial medical powers of attorney, medical directives, and I also help with probate and trust administration. And what that means is when people lose someone, they have to know what to do next, right? Maybe you've encountered this with your parents or with a spouse, but there's a long list of things that you have to do when someone passes. Big or small, everybody has some sort of circus, right? So it can be super complicated. And one of my best examples is when my husband's grandfather passed. All the grandchildren believed they were promised this little tiny piece of statuary. It wasn't worth really anything. It was sentimental. It looked like one of their old dogs. So I went on eBay and I found one just like it, and I ordered as many copies as I could. And I mailed one to everybody. And I said, you don't know if you're going to get the original, but you will still get the memory. And so I was happy to solve that problem. Not all problems are solvable. The story that I have on the slide is an example of the actual circus. The circus owner left most of the business to his son. That was inequitable. The daughter sued. This happens all day, every day. But the key here is they didn't really plan it out far enough in advance, or they didn't talk about it far enough in advance to make sure that a lawsuit didn't happen. If you think people fight only around large amounts of money, you're mistaken. People can fight over truly anything. Estate planning, though, is important because you want to head off the fight, right? Primarily, you want to identify who is going to help you, right? Who can do the hard part, write checks, go to the bank, clean out your closet, send things to Goodwill, who is organized and efficient and trustworthy. And the second part of that is figuring out who gets what and when, right? It could be as small as, right, a little statue in your house, right, to who is inheriting your IRA, which could be a larger sum of money. The thing most people think about, and like the story that Bunny said, is I don't have an estate plan. Everybody has an estate plan. The point is either you've chosen it or the government's chosen it for you. Because the state has default laws and the federal government has default laws if you don't have your own plan. So there are different types of ways to put together a plan. We're going to talk about some of them. One of them is through a will, right? We think of the last will and testament. This is where you choose the executor, right? Who does the work of your life, who is canceling your cable bill, who is planning your funeral, who is distributing the money. If you have young children, right, that's also who will take care of any young children, and it can be who will take care of your pets. A will is only effective when you pass. It is not confidential, and it does not avoid probate. We'll talk more a little bit about probate, but probate, I don't make these terms up, but probate is the fancy term for going through the court system when you pass, meaning a judge has to approve the will and how it's handled. Not being confidential means anything in the will is public information and can be disclosed. Famous people have their wills published online all the time. So if you're actually interested in a Hollywood starlet from years past or an important government figure, you could probably look up who they gave what to online. This is also why we get headlines. Right now we're seeing a lot of Lisa Marie Presley, what she inherited from her father, what's going to go to her kids. All that is public information. You may be familiar with a trust. So a will and a trust accomplish similar things, but they're different kinds of documents. I sort of say a good will is 15 to 20 pages, and a bad trust is about 30 to 40 pages. And so the difference there is a trust is a more foolproof plan with something that has a lot of backup and contingencies. A trust is a document you create now, and you transfer your property into it now, right? So your house is held in the trust, your bank accounts are held in the trust, and the trust is often the beneficiary of most of your assets. Then the trust says who gets it, when, so maybe not now, but maybe over time, 5, 10, 15, 20 years, and also under circumstances, right? So if you're worried about your money being mismanaged or spent poorly, you're leaving money to your kids, but you don't want them to get it all at once, you're worried they might be going through divorce or bankruptcy, the trust protects the money for your heirs under the terms you've set. It also is helpful if you want to leave money to grandchildren who are minors. The trust allows you to hold it for them until they're older and capable of handling the money, or to be used for school, or whatever sort of rules you put in place. Definitely some people who leave the money to their pets also goes into a pet trust for them so that the pets can be taken care of, the money's there, but you know that someone's going to take care of your pet, not just take the pet and the money and then decide not to keep the pet. Trusts are confidential and they avoid probate. So in Arizona, when people say they have a trust, usually their goal is to avoid probate and to make things easier for their kids. Charitable giving. So everything I've talked about so far can have a charitable piece. Charitable is both in life and when you pass. So when people talk about charitable giving in life, it could be making a commitment to a life and legacy campaign, right? So you've agreed while you're living that you're going to give your church or an educational institution or some other nonprofit a certain amount of money when you pass. You're asking then either your executor or your trustee to fulfill that wish. Other in-life giving is truly giving it while you're living, right? Some people want to see the results of their gift while they're living. It could be for tax reasons. So we sometimes set up a charitable trust where it says the trust gets a certain amount of money to the charity each year, and the remainder is saved for your family. But for example, if you were putting $1 million in a charitable trust, if it earned 3% each year, the church would get $30,000. At the end of your life or a certain term, the most common is 20 years, your family gets the original $1 million back. So so a lot of times we do this if people are worried about needing a tax benefit. If you have a nice house you bought in PV or Scottsdale or Phoenix years ago when the market was really low, and now you're selling it really high, there's a huge capital gains event. So one way to offset that capital gains event is to give more money to charity. You're still losing the money, right? I can't avoid some of that, but you're giving it for charity instead of to the government. Other ways that we talk about charitable giving is through beneficiary designations. And that means really on financial accounts, you're saying a certain amount goes to your selected charity when you pass. This happens a lot with IRAs. So in life, if you're taking RMDs, you pay taxes when that money comes out. A way to offset some of those taxes is directly from the R&D to give it to a charitable institution. So I know Bunny introduced, I'm on the board at the place where we worship. And so a lot of our members make their annual contribution through their IRA. It gives them tax savings and sort of guaranteed that that money is there for their membership contribution. Beneficiary designations can also be when you pass, right? So you've passed away and the account goes to the beneficiary. You can list a whole bunch of people, just one charitable organization. You have flexibility to divide the asset. The last way we talk about charitable giving is through either your trust or will beneficiary, right? So the documents that you sign could say, I'm giving 10% to my charity, I'm giving 80% to my children. You get to pick the rules and the amounts for each. So far we've talked about estate planning in terms of who inherits what. The other piece of estate planning is what happens if you're living but incapacitated. When clients come to me, the financial power of attorney is actually the document I'm most concerned about them signing. So this is if you are living but incapacitated, who can manage your finances? Who can write checks? Who can go to the bank? Who can talk to your financial advisor or accountant? Who does that work for you if you can't? So the downside is, if you become incapacitated, it's too late to sign. So the hope is that you pass away one day with never becoming incapacitated, right? But you sign the financial power of attorney just in case. And incapacity could be anything from short-term, car accident, to long-term, Alzheimer's, dementia, or Parkinson's. The key for the financial power of attorney is that you're choosing someone to help you. This person cannot be selfish. This person cannot take money from your account. Because if you're living and they've taken all your money and run away, you may know about it and you are the one who will suffer. Now that I've scared you. Medical directives. A lot of people want to plan what could happen to them and how they want someone to take care of them if they're ill. And again, this could be a long-term illness or short-term. The medical power of attorney appoints someone to make medical decisions for you. Often people, if you're married, you think, well, that's just my spouse. And it can be your spouse. Sometimes it needs to be your spouse plus someone else because they too are incapacitated. They are older. Perhaps they do not have the financial, emotional, or mental ability to make some of those decisions. You may not be on good terms with them, so you may need to pick someone anyways. The key here, sometimes I talk about with my clients, is when do you want to be taken to the hospital and when do you not, right? So do you have specific wishes? Have you already reached a place in your life where you no longer want some extraordinary measures, or you do? Some of extraordinary measures are talked about in a living will. So the living will is the document that says, I do not want ongoing life support. So it's different from a DNR. A DNR is a do not resuscitate. So the difference is you're in a car accident, right? The ambulance comes, you are resuscitated at the scene. You are taken to the hospital, and the hospital tells your family member or someone, hopefully you've designated in your plans to be your agent, it's not going well, right? Under what circumstances are we going to continue trying? Under what circumstances are we going to say goodbye? It's important for you to think about this if you have specific wishes. If you're worried that your children or other family members won't make the decision that you want, right or wrong. I'm an estate attorney. My father was an attorney, not an estate attorney, but I did draft plans for him. He passed away because he knew he was sick. I did not know he was sick. But at some point towards the end, the hospital called me during COVID, not fun, and said, does your father have a living will? And I said, no. He never signed one. So it was really hard for me to have to make that decision for him. I'm an only child, he wasn't married. It was all fell on my shoulders. And there is guilt there about whether you have done the right thing. So if there's someone in your life that you think might feel that same guilt, you might be doing this document just for them, even if not for yourself. HIPAA authorizations. Simple, short document. Again, something that I think is super important people sign, but they may not think about it. So a HIPAA authorization says if you are incapacitated, these are the people who can talk to your doctors and nurses about your condition. It could be your spouse, your children, It could be someone that you go to church with. It could be a friend. It could be a long list or a short list. A lot of times people think, well, if I'm sick, my family will talk to the doctor. It's not necessarily true, because the medical profession is prohibited from speaking to someone without authorization. Sometimes they will do it anyways, but sometimes they'll be super strict about it. There was actually a huge lawsuit in California a couple of years ago where doctors spoke without this permission, and they ended up having to pay over $1 million in damages. So now they're even more adherent to these standards. So again, once you're incapacitated, it's too late to sign. So this is just a key planning ahead document to think about. Funeral and memorial service. So I understand we have a competing event today, and that a lot of you have been already talking about what it means to plan your own funeral and memorial service. People can get super specific in terms of what you wish. I had a client once who wanted to make her ashes into a starfish and put into the ocean, and certain family members went to this celebration. A lot of my clients end up doing some sort of memorial bench if they're cremated, so that their family has a place to go to see them or say hello, but it's not just a grave. Obviously, the slide shows the Pringles founder being buried in a Pringles can. I have a lot of jokes sometimes online for people who want to be buried in a Diet Coke can. That's an important beverage in your life. That could be fun. So again, I talk about all of this about my family. My father passed away unexpectedly, and I did drive the 15 hours to Texas without stopping. I got there and the funeral home was like, well, what kind of music would you like to play? Clearly, I was not rational or on my best behavior. And I was like, what do you mean? And they're like, well, what do you want? And I was like, I'm paying you. Don't you have a playlist? You know, I was really offended. I was like, don't you have a plan for this? This is your job, not my job. And they were like, well, what's your dad's favorite song? I was like, I don't know. I feel bad. I guess we've never actually talked about it, right? And I was like, well, he wasn't religious, so don't play Amazing Grace, but like anything instrumental was fine. So again, my husband was like, you weren't very nice. And it was emotional, and so I recognized that, and I later apologized. And again, we paid them a ton of money, so that's my defense. But he didn't have a thought process at the time for what kind of music he would like to leave to. So if you have an idea, I actually have a Spotify channel to solve this for people now, because I faced this and found some lovely songs. Over the Rainbow is a very nice one. Just something to think about in terms of what you wish. Hopefully many of you have these documents, and this is just a refresher. For people who do, you don't always need to change them unless your life changes, right? Have you moved? Have you added or lost family members? Do you like your family more or less than you used to? Are the people still around? Have you changed income? So really important, when people put in their plans, I want to give a dollar figure to someone. As you go through life, your wealth may go up or down, and that dollar figure may not always make sense. So that's a quick thing to double check. That's basically it. I was going to leave you with one more story, and then I hope you have questions. A couple of years ago, I did a plan for a man who sold everything. He was moving, like 100%, sold all of his valuables, all of his tangible property, bought a van, and was leaving town. And we intentionally planned this so that he came to see me to sign his estate plans on a Friday at 4 o'clock as he was driving out of town. And he said, thank you for helping me get my life in order. If something happens, you'll hear from me, but I hope to never see you again. So I believe he is happily traveling the world, and one day his family will call me if they need anything. So that's it. Questions, concerns? Yeah? Do you want to come to the microphone? I know we have people on Zoom.
I have a trust that was done while I was living in Utah.
Okay.
I am now a legal resident of Michigan.
Okay.
But because my children live here, I know ultimately Arizona is probably where I'm going to kick the bucket. Tell me what I need to do.
Sure. So I will say, just like I said before, if you came to me, I would say, look, I want to make sure that you have an Arizona financial and medical power of attorney, because if that's where you are and something happens, we would want to make sure that your kids have the right access and that no one denies them access. Should you update your trust? I mean, it really depends on which kind of lawyer you talk to. If your wishes are the same, so long as the document was legally executed, meaning you signed and it's notarized, you should be fine. If there are things you want to update, or sometimes I really just do a simple amendment that says, please apply my trust under Arizona law, you can. I don't know about Michigan. People who come to me from California, I do a simple amendment because California tax laws are totally different. And California now has an inheritance tax, and so I don't want my clients to have to pay that. So that would just be like a quick research, what's, Utah or Michigan, tax law, but you could solve that. If everything else is the same, you could sort of in a 1 to 2 page document do an update if you're feeling conservative. If you don't really care and your kids will figure it out, then it's not legally required. Makes sense? Anybody else?
Allison, there's a question from the chat. The question, whoops, hold on just a second. The first question is, do you need to refinance your mortgage to have it in your trust name? If not, how?
So the answer is no. So when we do a trust, we're going to put the assets in the trust, but not the debts. So I want to make sure the house title is in the name of the trust, but you would hold your mortgage in your personal name. Obviously, when the house is sold, either in your life or later, the mortgage gets paid off, right? There's no getting around that. But you don't have to change the mortgage to be in the trust just because you have a trust.
With the trust, is it recorded in the state of Arizona?
So the only thing that gets recorded is a house deed. So the
That's
trust
all.
itself lives with you, right?
Okay.
In a notebook, in an electronic file, however it is. So the good and bad of this is the trust is confidential, right? So you have to tell somebody where it is and you're trusting them, that they will follow it. But there's no policing of this in sort of the real world.
Okay, thank you. One more thing. If I wanted to make a change to the trust, do I have to do it through a lawyer, or can I simply put down that I want something?
So if you're making a change, it needs to be signed and notarized.
Okay. Okay, thank you.
Allison, there's another question from the chat. This is more about a deed. First of all, the person says, I have a house. I'm the only homeowner. The house is in my name before I got married, and I took my husband's name. So do I need to change my name on the deed? Second part of that question is, how do I add my husband to the deed of my home, being the only homeowner? I know it's only a community property state, but does that mean it will automatically go to him? Doesn't his name need to be on the deed?
So if you want to avoid probate, his name should be on the deed. So I would do a quick claim that said, first name, original name, AKA new married name, right? So mine would be Allison Harvey, AKA Allison Kierman, and spouse's name as community property with rights of survivorship. And if you go to the Maricopa County Recorder's Office, unfortunately it's downtown Phoenix, then they have forms online where they can help you.
This isn't in the chat, but as a side to that, or an added to that, can you describe what happens to your home when you put it in a trust?
Sure. I mean, I guess while you're living, nothing happens, right? And some of this is like a legal fiction, right? It's sort of like Peter Pan's lockbox. We're doing it, but you can't see it or feel it. So putting the house in trust means you're retitling it. So the trust name is on the deed. Your property statement for taxes come next year in the name of the trust. And if somebody looked it up on the assessor's website, it wouldn't say your name, it would say the trust name. You want to make sure that you add the trust to your homeowner's insurance policy. That way they can't get out of paying if something happens. The trust then says what happens to the house, either when you're incapacitated, it's sold or not, somebody could live in it or not, and what happens to the house when you pass. So I see a lot of relationships that aren't a formal marriage, but they want their partner to be able to stay in the house. So the trust says how long they can stay, under what circumstances, do they have to be single, and who pays for what, right? Who pays for the mortgage, the utilities, the taxes, the insurance. So the trust lays out that very specific language about what happens to the house when you pass. If your trust just says, I give everything equally to my children when I pass, the kids get to decide. Are we keeping the house? Are we just selling it? A lot of times it's sold. The money's put in a bank account and divided between however many kids there are. Sometimes one of the kids wants to keep the house. I have a man from Canada, actually, his son had a house here and passed away, and he just kept it. He was like, well, now I'm a snowbird. So they get to decide unless the trust is more specific.
I'm a single woman, never married, no children, and I own a house. It's not worth a great deal, and a car that, and all the things that are in the house. But I have a half-sister in another state. She's my only relative that would want any of this. What do I do?
So I will say some easy things are, you can do what's called a beneficiary deed for your house, which says you do record it, but it says the house is inherited by my half-sister when I pass. You can do the same thing for your car. And then if you have a bank account, for example, you would want to go to the bank and make her the beneficiary of those accounts.
And what about all the stuff in the house?
If you want for her to have it, it would just be, I mean, you could sign a simple will that says all my worldly goods go to her.
I see. Okay, thank you.
This is from the chat. Someone's thinking about moving to Delaware and wondering if they should wait a few years before starting a trust. I'm 38 years old, but I also know anything unexpectedly can happen. I would also be renting out this property to see if I'm happy in Delaware.
So that part's hard, right? I think you have to decide, are you feeling more conservative or not, right? So the conservative plan is do the plan based on your life now, with the acknowledgement that you might have to spend a little more money to change it in the future. The other plan is to do nothing and wait and see. Obviously, my big concerns are your powers of attorney, because if you become incapacitated between now and then, it's too late. So, it's always kind of the risk. If it works economically, then I would say do it. And if it doesn't work economically, then you just have to understand that's the risk. Other questions?
Just to follow up, Allison, on a previous question about a deed in a home owned by a person and their spouse, or if, again, the person's just wanting clarification, if a house is in my name before I got married and took his name, do I need to change my name on the deed?
The answer is, so I guess it's both, right? Yes and no. There's no legal obligation that you change the name. But when you pass, that has to be clarified, right? So the person still living will have to open, either way, in this case, there's the possibility of probate, but it's likely that someone would have to open probate to clarify, this is Allison Harvey, who is married, right? Either death certificate that shows what the maiden versus married name is would have to be recorded, and then the probate court would give you authorization to transfer the property to spouse or to next in line family member. So I guess there's, again, no policing of this, so nobody's gonna come and say you don't own the house because your name's not on it, but at the same time, the legal clarification has to be done at some point. And though it is annoying, it is always easier for the person to do it while they're living than to leave it for somebody else to do later. There's just additional hoops to go through if you're not here. People on Zoom are very chatty.
Some of the information you gave about a quitclaim deed was quite a bit of information. Is there any place people can go to, either online, to get the information for Arizona so that they could read more about that or what they should be doing?
I'm going to say, Google is our friend and our enemy, right? I'm sure if you Googled Arizona quitclaim deeds, you could buy a sample online. Again, if you go to the Maricopa County Recorder's Office, they have a help desk and they will help you. Obviously, my website, just not up here, but kiermanlaw.com. I have a lot of information and write a lot of blog articles and have a lot of FAQ videos. So if you're looking for something general, that's where you get started. But if you want to execute a deed, you need to either hire an attorney or go to the county recorder's office for real help. Anybody else? All right. Well, thank you so much for coming. I know this was recorded, so if you have other questions or want to review it, or one of your friends asks you how it went great, just FYI. And they can always find out more. Are we good, Ted? Was there anything else we need to do? All right. Thank you so much for coming. I really appreciate it. Hope you have a nice Sunday afternoon.